Hello, good morning, students. Please subscribe the channel, drop a like, share, and comment. This is Shree Vishnu Art Press Publications, exercise number 9 and 10 on the speed of 90 words per minute. Start. Being aggrieved by the judgment and order dated 22/8/2008 passed by the Division Bench of the High Court, the present appeals have been preferred by the appellants herein. While issuing notice on 13/10/2008, this court passed an interim order holding and observing that the appointment of computer instructors pursuant to the orders passed by the High Court allowing the state government to proceed with the process of appointment of computer instructors would be subject to the result of appeals. The effect of the aforesaid order was that there was no bar on the part of the state government to proceed and continue with the appointment process of such computer instructors, but would be subject to further orders of this court. Consequently, the state government announced the date of the special recruitment test, that is on 12/10/2008. The said test was held on the said notified date, and the result of the examination was also published. A list of the candidates who appeared and succeeded in the said test was also published. It transpires from the records placed before us that a total of 1714 candidates appeared in the special recruitment test in terms of the criteria laid down by the selection board. The minimum qualifying marks for the posts of computer instructors was fixed as 50%, that is 75 marks out of total 150 marks. The said qualifying criteria was laid down in the meeting held on 10/10/2006, wherein representatives of the government was also present. On the night of 12/10/2008, the respondent number 3 published the list of provisionally selected candidates for appointment to the post of computer instructors based on the special recruitment test on the internet. While publishing the said marks of the candidates, it was made clear that all candidates who have secured 35% marks in the special recruitment test would be called for certificate verification. It is thus established that the state government reduced the minimum qualifying marks for the post of computer instructors to 35%, which is contrary to an earlier decision taken in a meeting held on 10/10/2006 that the minimum qualifying marks for filling up the posts of computer instructors would be 50%, that is 75 marks out of total 150 marks. It is thus established that the government changed the rules of recruitment and terms and conditions of appointment in the midway after the selection process was initiated. The said decision was taken on Sunday, that is on 12/10/2008, after the candidates had taken their exam. It also transpires from the record that out of 1686 candidates, only 857 candidates had in fact secured 50% marks, that is 75 marks out of 150 marks, whereas 8 to 9 candidates secured marks between 35% and 50%, that is less than 75 marks out of 150 marks. It is also indicated from the said result published that out of 1714 candidates who had taken the special recruitment test, it is 1686 candidates who were found to have secured more than 35% marks, and they were provisionally selected for certificate verification. The brief facts of this case are that the petitioner took a loan from the respondent Bank of Baroda to the tune of rupees 1 crore, which was enhanced to rupees 2.65 crore. Since there was default in repayment of the same, the respondent bank filed an application before the Debts Recovery Tribunal, Allahabad, hereinafter referred to as the DRT, for recovery of over rupees 4 crore. The petitioner submitted its reply and had also taken time to settle the dues through one-time settlement scheme. However, the matter could not get resolved. The petitioner then filed an application praying that the original application having been filed without approaching the High Power Committee and without serving notice under Section 117 of the UP Cooperative Societies Act 1965 would be liable to be dismissed. In the said application, further plea was taken that the original application filed by the respondent bank suffers from the defect of misjoinder of necessary parties and non-joinder of the receiver appointed by the Bombay High Court. Such application of the petitioner was dismissed by the DRT. Challenging the said order, the petitioner filed an appeal before the Debts Recovery Appellate Tribunal, Allahabad, hereinafter referred to as the DRAT, which was also dismissed vide its detailed order dated 27/10/2008. Challenging the said orders, this writ petition has been filed. The submission of the learned counsel for the petitioner is that prior to the filing of the suit against the petitioner or its officers, notice in writing to the registrar of the cooperative society ought to have been given, which has not been done. Hence, the original application filed by the respondent bank was not maintainable. His other submission is that prior to entering into the controversy with regard to the liability of payment, the matter should have been referred to the High Power Committee for resolving the dispute, which was between petitioner, which is a cooperative society of the state government, and the bank, which is also an instrumentality of the state. It was then argued that several parties have been joined who were not necessary, and the receiver appointed by the Bombay High Court, who was a necessary party, has not been joined, and as such the original application ought to have been dismissed by the DRT on the ground of misjoinder of parties and non-joinder of necessary party. In the present case, there is no such procedural defect which required to be cured. The petitioner admits having taken loan and claims that the same could not be repaid because of financial loss. The tribunal is obliged under law to issue recovery for the amount which is admitted by the party. Since the petitioner admits its liability, it was the duty of the tribunal to have issued the recovery certificate against the petitioner immediately after the liability had been accepted by the petitioner. Such is a mandate of law, and the tribunal ought to have followed the same. Technicalities of procedure should not be allowed to defeat the cause of justice.